begitu. Yes, please stop.
Lordship.
My lord, may I mention a case, my lord? Order serial number 47, my lord. In this
Let the
case,
matter
my
be
lord, I pray for 2 weeks' time, my lord.
Let the matter be called first.
My lord.
Yes.
J. Lordship. With permission, Lordship. We have received 5 mention cases, Lordship, for urgent hearing, Lordship.
Tomorrow.
J. Under the heading for judgment, CWJC 4417 of 2011. Arun Kumar Shukla versus the Union of India and others. For the petitioner, Shri Deepak Kumar. For the Union of India, Senior Advocate Mrs. Nivedita Nirvikar, Radhika Raman, Praveen Kumar Sinha.
Tomorrow.
Under the heading for order. Serial number 2, CWJC 2536 of 2021. Sarwan Kumar versus the Regional Manager, Bihar Kshetriya Gramin Bank. For the petitioner, Shri Ranjit Kumar Singh. For the bank, Shri Mukesh Kumar number 1. Shri
May I
Ranjit Kumar Singh.
May I permitted to withdraw this application, my lord.
Learned counsel for the petitioner seeks permission to withdraw this application. This application is accordingly dismissed as withdrawn.
My lord, my appearance should be noted, my lord.
Mr. Mukesh Kumar, learned counsel for the bank, has no objection to withdrawal of the writ application.
Serial number 3.
Oblige, my lord.
CWJC 6193 of 2021. Virendra Prasad Yadav versus the State of Bihar through the Chief Secretary. For the petitioner, Messrs. Kumar Kaushik and Namrata Dubey. For the state, Shri Yogendra Prasad Sinha, AG 7. For the corporation, Senior Advocate Shri Amit Srivastava with Sanjeev Nikesh. Shri Kumar Kaushik.
May it please your lordship. In this case, my lord,
Mr. Kaushik, pleadings are complete.
one counter affidavit has been filed on behalf of the sixth respondent.
Whether any
Thereafter-
affidavit is required by any other respondent.
My lord, earlier, despite filing of this affidavit, time was sought by the last order to file a supplementary counter affidavit. It has not yet been served upon me.
Who has to file?
State respondents, my lord.
Why? Who is appearing for the state?
Shri Yogendra Prasad Sinha, AG 7.
And since during the pendency of the writ application, the final notification constituting the urban bodies have been published, I have assailed it by filing an interlocutory application.
We will consider, let them file counter affidavit first.
My lord.
No, but was there any direction for the state to file counter affidavit?
My lord will find order dated 25/3/2021.
That affidavit has been filed by the State Election Commission.
I have one counter affidavit filed on behalf of the respondent number 6.
Respondent number 6 is? All right.
District Magistrate. It is
Who is
dated
appearing for
24.
the State Election Commission? Who is appearing?
Shri Amit
My lord.
Srivastava, Senior Advocate with Sanjeev Nikesh. Shri Sanjeev Nikesh, please unmute your mic. Shri
Mr. Sanjeev
Sanjeev Nikesh, please unmute your mic.
Mr. Sanjeev Nikesh, please unmute your mic. By way of last indulgence, 1 week time is allowed for the state respondents to comply with the order dated 25/3/2021. First off, further, the state respondents are also directed to file counter affidavit within the aforesaid period dealing with the averments made in the counter affidavit has also IA number 1/2022 filed on behalf of the petitioner seeking amendment in the writ petition. Please this matter next Tuesday.
Obliged, Your Lord.
Serial number 4. CWJC 6353 of 2021. Messrs. Gauri Petroleum versus the Indian Oil Corporation Limited for the petitioner Messrs. Satya Prakash, Praveen Kumar, Rudrang, Shivam Singh.
Your Lordship, I appear on behalf of the Indian Oil Corporation. The
Yes.
petitioner may be directed to serve a copy upon the counsel for the corporation.
My lords, I appear for the petitioner, my lords.
Have you not served?
My lords, it was served, but since
see.
Mr. Satya Prakash, my lords, he's no more.
All right.
He had filed it, so I
We will take
really
the
don't
matter
know.
tomorrow. You, in the meanwhile, you can serve a copy.
Very well, my lords, very well. Obliged. I'll do that, my
Let a
lords.
copy of the writ application be served by learned counsel for the petitioner on Mr. Ankit Katria, learned counsel who represents Indian Oil Corporation Limited in course of the day. So stop. Let's discuss tomorrow.
Obliged, my lords, obliged.
Serial number 5. CWJC 13364 of 2021. Chandradeep Kumar versus the State of Bihar through the Revenue Secretary for the petitioner Mrs. Mahasweta Chatterjee for the Religious Trust Board, Senior Advocate Sri Ganpati Trivedi.
I am for the state, my lord. Copy of the writ petition has not been served to the SC25, my lord.
SC25 has no right to receive a copy from the petitioner.
May-
25 can collect a copy from the office of the Advocate General.
No, there is no copy, my lords. I
There is
have
no
sent
copy.
the Munshi, my lord. There is no copy in the AG office.
Who is for the petitioner?
Mahacheta Chatterjee, my lord.
Despite 2 weeks.
Appearing for the board, my lord.
Obliged, my lord.
Just a minute. Just a minute.
May पता नहीं कंफ्यूज है सीरियल नंबर 7 है
जी लॉर्ड.
Yes.
Serial number 6. CWJC 15223 of 2021.
Lord, I
Messrs.
appear on behalf
Dhaneshwar
of the
Nath Construction versus the State of Bihar for the petitioner Messrs. Lal Babu Singh, Umesh Kumar Gupta for the estate Srimati Archana Meenakshi GP6.
Lord, I appear on behalf of the petitioner, my lord. My lord, the matter relates to debarment of the petitioner, my lord, who is a contractor, my lord. My lord, on earlier occasion, this case was heard, my lord. And kindly see the last order, my lord. And I have also filed an IA petition for a stay of the operation of the impugned order, my lord. And although pleadings are complete, my lord, the respondents have already filed counter affidavit, my lord. I have also filed.
In this case, my lord, I am appearing on behalf of the state, my lord.
Yes.
The debarment has been lifted, my lord. And I have also sent a copy of, today I have received the instruction, my lord. And
Yes.
I have sent one letter which I have received, my lord, to the Land Council for the petitioner, my lord.
So what then, Mr. Singh?
My lord, but it may take time, my lord. I have already completed the maintenance work of the
Maintenance work is different. We will not go into that. So far, debarment is concerned, that is over.
My
But
lord.
still they have not passed any order.
No, this is what they are saying, that debarment order has been lifted.
Yes, I have sent one letter, my lord, to the council for the petitioner, my lord.
Then
I have not received any letter.
Yes, in view of the letter, my lord, your lordship can dispose of this application.
My lord, the letter is only a recommendation made by the executive engineer to the higher authority. I have also received a letter from my client, my lord, but that letter is only a recommendation. But as far as, my lord, debarment is concerned, it is still in existence. Only a recommendation.
all right, all right. Land Council representing the state of Bihar informs this court that the impugned order of debarment has since been lifted by the competent authority.
My lord.
So stop. A copy of necessary communication.
Annexure 7 है वो कि क्या है?
Necessary. A letter in this regard has been sent to the petitioner, he submits. So stop. Let copy of the said letter be sent to the court electronically. So stop. The matter will be taken up again tomorrow.
क्या हम लोग बोले हैं कि कमेटी द्वारा हमको नोटिस नहीं दी गई?
All right, tomorrow.
My lord.
Send a copy.
My lord.
Mr. Singh, in the meanwhile, you just examine if the order of debarment has been lifted, then
nothing left, my lord.
Yes.
Serial number 7. CWJC 16795 of 2021. Mahant Ramesh Giri versus the State of Bihar for the petitioner Messrs. Amit Kumar, Ravi Ranjan and Ambrish Kumar. For the Religious Trust Board, Senior Advocate Sri Ganpati Trivedi. For the State, Sri S.K. Mandal, SC3.
May it please your lordship. My lords, the validity of the second order. First order was quashed by the Honorable Court, my lords, in terms of Annexure 5 to the writ petition. Now again a fresh order has been passed, my lords, purporting to be under Section 33 of the Act. Without following, my lord, the procedure prescribed under Section 28(2)H of the Religious Trust Board Act, which is a condition precedent for passing any order under Section 33 of the Act. My lord, say a new scheme has been prescribed in pursuance of, my lord, say the notification, my lord, say is 29/7/2021, which will be the last three pages, my lords, of the order.
Where is the impugned order?
At page 47, my lords, page 44 is the purported notice. Notice, my lords, earlier pursuant to which the order was passed, which was quashed, my lords, in terms of section Annexure 5 to the writ petition by this Honorable Court. Then, my lords, the matter was remanded and again on the old notice itself, a fresh order has been passed, my lords, without following the, if I may draw your lordship's kind attention to page, my lords, 50, 47, my lords, the impugned order starts. After 3 pages,
No, the order has been passed in exercise of power under section 33.
33. Without following, my lords, the procedure prescribed under section 28H to 2H of the Act. First of all, my lords, the erstwhile my lords trustee has to be removed, my lords, then only a new scheme with new body, my lords, will come in. Ever since 1988, my lords, there are consistent decisions of your lordship's court,
No,
my lords.
where is the final order? What is the effect of this order?
The effect of page 50, my lords, may kindly be seen.
Yes.
Uh, 6 persons have been named, my lords, below the middle, and before that, उक्त पर विचार करते हुए अधिनियम की धारा 33 के तहत अगले आदेश तक प्रशासनिक आर्थिक व्यवस्था एवं संपत्ति की सुरक्षा हेतु समिति का गठन किया जाता है. This is, my lords, in exercise of the power under section 33 of the Act.
So this is an interim measure.
Maybe, my lords, but my lords, the erstwhile, my lords, there are two, the erstwhile, my lords, trustee is there, then my lords, a new committee has been established there, constituted there, my lords, taking charge. He has been made a wandering Jew, my lords, in 22nd century. Section 33, my lords, I have quoted in the petition itself.
Yes.
If it is your lordship's kind pleasure to refer to page 10 of the petition, my lord, section 33, I have quoted. If the book is not available there. The last 3 lines will be attracted in this case.
Yes.
For where there is a vacancy caused by the order of the board passed under clause H of subsection 2 of section 28 of the Act. The board may, subject to any order of a competent court, appoint any person to act as a trustee of the said trust. The petitioner before your lordship, my lords, was duly appointed in 2013 itself, acknowledged and confirmed by the board also in terms of annexure 2 to the writ petition. Two and 3. Initially appointed, my lords, for 1 year, then my lords confirmed as no objection was taken to his monthship. Therefore, my lord, in terms of the order, he was confirmed, he has been acting, my lords, and performing his duties.
No, we are trying to understand, Mr. Chaube, whether you have any remedy under against such decision of the board or not.
My lord, since my lords, my lords, in my respectful submission, my lords, there is no subject to what.
No statutory remedy.
My lords, perhaps against such an order there is none.
Such an
Earlier
order. Such an order, Mr. Chaube, that is a very difficult proposition. The question is availability of alternative remedy. Even if alternative remedy is available, in exceptional circumstance, this court may exercise jurisdiction. But that exceptional circumstance must exist Therefore, we wanted to know if you have alternative remedy, whether there is any exceptional circumstances exists.
Milord, earlier also an identical order was passed, against which, Milord, the power was exercised by the Honorable Court in terms of Annexure 5 to the writ petition. That is the judgment of this Honorable Court, Milord.
No, but the Supreme Court is deprecating such approach of the High Court repeatedly. And if there is any alternative remedy, they should go to that court.
Plus, that order was set aside because it was passed by the president for lack of jurisdiction. Therefore, it was remanded to the board. That was on a totally different ground.
No, Milord, say, if it is your lordship's kind pleasure to see.
Yes. Yes, it was passed by the president. Therefore, it was sent back to the board.
If my lord permit me, I must clarify the situation, my lord. At that time, only president was appointed. Board was not constituted. So the submission was that unless the board is constituted, the president cannot exercise its power under delegated power, my lord. That's why the reason. And since the board was constituted, the matter was remitted back to the board for president to consider pass in accordance with law.
Plus, in the present, there is no appointment of any Mahant. It is just an interim measure comprising of certain state officials ex officio for the best administration of the trust pending determination of the dispute between two claimants. The order has taken care to say that nobody is being appointed for the present in the last paragraph. At page 15.
Yes, Mr. Chaw.
The last paragraph of the impugned order. जब तक महंती के बिंदु पर कोई निर्णय नहीं लिया जाता, तब तक महंत का आसन ग्रहण किसी व्यक्ति द्वारा नहीं किया जाता. It is an interim measure comprising of some state officials ex officio to for the best management pending determination of the dispute. No right has been determined.
That's all, Mr.
My lord, say, under the pretext of the impugned order, my lord, say, still, my lords, this question stares at the face that section 28 2H has not been followed.
Let us see.
Nor, my lord, there is any contemplation so far. District Judge वाला. Section 48. No.
Where is your removal?
There is no removal as such.
He has not been removed. The very first paragraph of the notification specifically says, my lord, last line, इस संबंध में महंत रमेश गिरी के अधिवक्ता का कथन है, रमेश गिरी को कभी भी महंत के पद से हटाया नहीं गया है, न कोई आदेश उनके विरुद्ध पारित किया गया है.
We will come back to you, Mr. Trivedi.
Sorry, my lord.
Yes, Mr. Chaubey. So there
is no, my lord, resort to section 28 2H.
That is not required because no order has been passed.
No, my lord, they are exercising their power, my lord, under section 33, and my lord, an order, my lord, under section 28 2H of the Act is mandatory. It is a precondition, my lord. It is a condition precedent, my lord, section 33 itself may kindly be seen. Other, my lord's contingencies, my lords,
Mr. Chaubey, please read the whole section.
Yes.
Is one of the contingencies. Section 228 2H is one of the situation where the interim, by way of interim measure, a board can be constituted, committee can be constituted. But there are other, where there is vacancy in the office of the trustee of our
Milords, other conditions, Milords, are not fulfilled. Other conditions not being fulfilled, Milords, the only condition, Milords, which may be attracted, but it has not been resorted to. That is my respectful submission. And covered by Milords 2003, since 1988, Milords, there are several decisions of your Lordship's court, Milords, that unless that is a condition precedent. It is hazed in with a condition precedent which has to be followed.
Yes.
Other conditions, Milords, contemplated under section 33, it is not their case, Milords, that it is being attracted.
Yes.
Therefore, the only power, Milords, that they can exercise it after following, Milords, 22H of the.
Yes. Anything else on
If you-
alternative remedy, Mr. Chaubey?
Milords, it does not appear, Milords, to me to be any alternative remedy.
Yes. Any other submission, Mr. Chaubey?
Milords, it is said in the impugned order that there was a committee appointed by them to inquire into the allegations made, Milords, against the petitioner. But no notice of the same was ever given to. On the basis of an ex parte, Milords, and some inquiry purported, some inquiry report, the impugned order has been passed. And it has the effect, Milords, under section 33.
All right. Anything else, Mr. Chaubey?
Okay.
Yes, Mr.
These are my respectful. These are my respectful.
Yes, Mr. Giri. Sorry, Mr. Trivedi. I'm so sorry.
Milords, some decisions I may refer to for your Lordship's kind consideration.
Yes.
That is, Milords, 1988 PAGR page 212.
Yes.
1989 Patna, Milords, page 340.
340. 1989 Patna page.
89 Patna page 349.
49. Yes. Any other decision?
2003 volume 4 PLGR page 710.
Yes.
Resort to 28H is a precondition.
We will consider.
There must be vacancy after removal, Milords, after exercise of the power. Then only the power under section 33 can be exercised.
Yes.
Either permanently or temporary.
Yes.
1998 3 PLGR, Milords.
1998 volume 3. I don't think that volume 3 was not there in 1988. Was there in volume 3 in 1988?
That is what the book is saying, Milords. Of course, I have not checked up. I may check it up and then, Milords, confirm it.
1998
volume 3 है कि नहीं है?
1998, not 88, sir.
1998.
Yes.
88 भी बोले हैं हुजूर, page 212.
Yeah, that we have noted. All right. Sorry.
Yes.
1998.
3 volume.
Volume 3 PL, yeah.
Page 347, that is what the book is saying. I am checking it up, then Milords, I shall
No, this
confirm.
will be correct. I was under the impression that you are referring to 1988. So there was no volume 1988.
1988 PLGR is 212 only, Milords. And one more decision, Milords, 1993 Patna, page 171.
All right.
It says, Milords, that if an authority of or a person is making complaint and he is not a relevant one, contemplated under the act, then he become, my lord, a stranger. The committee also become a stranger, my lord, and on its report here, my lord, it is ex parte. No order can be passed.
Right.
These are my respectful comments.
All right. Yes, Mr. Trivedi.
1983 है ना?
From the very notification, my lord, from the very notification, it appears a committee has been constituted under section 32. Section 33, my lord, tells about the removal of power to appoint a temporary trustee. My lord, in this case, the trustee had the existing trustee, Ramesh Giri, has not been
without meaning to intervene.
Been removed from his office. He has
An
not been
amendment
removed.
order is.
We will come back. We will come back. Let him complete. In virtual proceedings, it will become difficult if side-by-side argument. We will come back.
Very well.
Yes, Mr. Trivedi.
From the very first paragraph, it appears, my lord, there is a dispute with respect to Mahantship. My lord, if I permitted to place that, my lord, from the after just 7 to 8 lines below top, my lord.
Yes.
याचिका के विचाराधीन होते हुए रमेश गिरी मठ छोड़कर बनारस या कहीं अन्यत्र चल रहने लगे। इस संबंध में उन्होंने कोई पत्र भी परिषद को दिया कि वह डर या बस से छोड़ रहे हैं और वर्ष 2020 से इस मठ में नहीं रह रहे हैं। इसी बीच त्रिवेणी गिरी द्वारा परिषद को पत्र एवं फोटोग्राफ उपलब्ध कराया गया कि साधु संतों और समाज के लोगों द्वारा उनके महंत नियुक्त किया गया है। इस संबंध में त्रिवेणी गिरी को अभी परिषद तक द्वारा मान्यता नहीं दी गई है, क्योंकि यह सुनवाई का विषय है। इस संबंध में महंत रमेश गिरी के अधिवक्ता का कथन है कि रमेश गिरी को कभी भी महंत के पद से हटाया नहीं गया है, न कोई आदेश के विरुद्ध पारित किया गया है। उपरोक्त सभी परिस्थितियों पर स्पष्ट करती है कि महंतों की नियुक्ति के संबंध में गंभीर विवाद है और इस विवाद के चलते मठ की संपत्ति या दुरुपयोग हो रहा है। इन्हें अतिक्रमण कर अवैध निर्माण भी किया जा रहा है। दुकानदार आदि द्वारा भी सही तरीके से किराया नहीं दिया जा रहा है। सभी सत्य आय व्यय विवरण की किसी भी पक्ष को द्वारा दाखिल नहीं की गई है। अतः मठ के प्रबंधन में न केवल आर्थिक एवं प्रशासनिक गंभीर समस्या है, बल्कि इसके साथ साथ मठ के अंदर सभी पक्षों के बीच शांति भंग की साथ साथ किसी अप्रिय घटना से इनकार नहीं किया जा सकता है। सभी पक्षों की तरफ से यह प्रार्थना की जा रही है कि जब तक कोई निर्णय नहीं लिया जाता है, तब तक मंदिर की व्यवस्था प्रशासनिक पदाधिकारियों की एक समिति बनाकर कर ली जाए। अतः बिहार हिंदू धार्मिक न्यास अधिनियम धारा 32 के प्रावधानों के प्रयोग करते हुए बोधगया मठ स्वयं सुरक्षा दुकानों सुरक्षित करने के so my lord, it is an interim measure. It is not neither any temporary trustee has been appointed nor he has been removed. Just to keep the management of the temple in order, a committee of administrative officers have been constituted, and the matter is yet to be heard, finally taken a decision. So my lord, it is, my lord, preempting an issue, my lord. Just it is anticipated he may be removed or he may not be removed. So my lord, this writ is not maintainable. As regards section 32 is concerned, my lord, if a committee is constituted, my lord, then for that remedy lies before the district judge under subsection 3 of section 32. Keeping in view of the rival claim of 2 persons, Ramesh Giri and one, my lord, Triveni Giri, the situation has become worse. The petitioners were heard, my lord. It is apparent from order dated 27/7/2021.
No, why are you referring to subsection 3? Subsection 3 has no application.
My lord, if a committee has been constituted, my lord, under section, of course, my lord, it is not a section 32 because that has been corrected by a subsequent notification, my lord, by telling that there is an error in writing in section 33. Instead of it should be 33. My lord, this is an interim measure, my lord. No temporary trustee has been appointed also. A temporary trustee must be one person. He is yet to be appointed. Now a committee has been, an interim measure has been taken by the president for the protection of the property of the mutt.
So therefore, Mr. Chaubey is correct in his submission that there is no statutory alternative remedy against the order which has been passed. The order may be legal, illegal, valid, invalid, that's a different matter. But no, statutory remedy is not there against that order under the Act.
My lord, under section 33, my lord, there is no statutory remedy.
All right. Then when it says subject to any order of the court, then it refers to any order passed under section 32.
No, my lord. That is, my lord, that is taking, but once a temporary trustee is appointed and it completes 1 year, in appointing a person as trustee under subsection 1, the board shall possible select a person of the section to which the last trustee belongs.
Mr. Trivedi, there are 3-4 circumstances where such temporary committee can be constituted as envisaged in section 33. Is when there is vacancy in the office of the trustee of a religious trust and there is no one competent to be appointed as trustee under the terms of deed of such trust. This is one circumstance. The second circumstance is or where there is a bona fide dispute as to right of any person to act as trustee, and in the opinion of the board there is likelihood of breach of peace, or where there is a vacancy by the order of the board passed under clause H. This is third circumstance. So
my lord,
the 3 circumstances. So not only clause subsection 2H of section 22, but there are other 2 situations which when exist, a temporary committee can be constituted by the board.
My lord, here there are 2 claimants, my lord, keeping now the 2 persons are laying claim because it has been alleged that the present trustee is not living at the
Mr. Trivedi, we want to refer to this expression. Board may subject to any order of a competent court. What does this mean? What does it refer to? May subject to any. Is there any?
That is, my lord, till the dispute between the claiming 2 trustees is decided. If it is not decided 1 year, then section 32 will be there, my lord. Board will frame its scheme.
Yes, we will see. Yes, Mr. Chaubey, you wanted to say something?
Yes, my lord, 32 has been amended to be, my lord, 33. That is what I wanted to refer.
32 has been?
In the subsequent order, my lord, this error has been corrected.
Yes.
After
33 has been mentioned.
Lord, this is what I wanted to throw to you.
All right. That we have
And
seen.
my lord, yes. These are my respectful.
Tomorrow for orders? For judgment?
Lordship. As it pleases your lordship.
Tomorrow. Yeah, brother.
There is an IA also, my lords, if it is your lordship's kind pleasure to admit it, then, my lords, there is an IA forestry also. That your lordship will kindly.
We will decide it. We will decide it by tomorrow.
Lordship.
On factual aspect, my lord, I have not been able to file counter affidavit, my lord. If it is required, it is on purely heard on, my lord, law point.
Mr. Trivedi, we'll see. If tomorrow we feel that any counter affidavit is required, we will judgment. But if we are satisfied, if we are of the opinion that no affidavit is required, then we will decide accordingly.
Lordship.
Serial number 8. CWJC 19280 of 2021. Vidya Bhushan Paswan versus the State of Bihar for the petitioner Sri Jayaprakash Barba, for the state Srimati Archana Meenakshi GP6.
contested the election of Mukhia, Gram Panchayat Raj Khajri Block Nawatpur, my lord.
File
And
election
the
petition.
counting, not in view of 79 rule 79 not and the division bench decision of the Supreme Court I have quoted, not I had filed not on the date of counting itself, not I had filed objection. Rule 79 notes I have quoted in the petition. Not rule 79 says that the candidate or in his or her absence, his election agent or contingent may make a written application to the returning officer or officer authorized by him or her for recounting of votes, stating therein the ground for the same. The returning officer or the officer authorized by him or her may fully or partly accept or reject the application, stating the reason for the same. Not the on the date of counting itself, not the I have filed
Cannot
series
go
of
into those
representation.
aspects. If you want to file election petition, it's all right. You don't want, you don't file. Because he cannot entertain that petition.
Permitted. Delay may be not.
Huh? What do you want?
Not delay, not so far the time is permission may be liberty may be given to file limitation.
You may learn counsel for the petitioner after some argument seeks permission to withdraw this application with a liberty to prefer an election petition questioning the election of
Mukhia, my lord.
Of Mukhia of Gram Panchayat Khajori in the district of Patna. First off, the writ application is accordingly dismissed as withdrawn with a liberty as sought. First off, it will be open for the petitioner to seek condonation of delay in filing election petition if the same is permissible in accordance with law.
Obliging.
Serial number 9. CWJC 19522 of 2021. Preeti Kumari Chaurasia versus the State of Bihar for the petitioner Messrs. Rajiv Kumar Singh, Pranav Kumar and Alok Kumar Singh. For the state, Shri Kameshwar Prasad Gupta, GP10. For the Panchayat, Shri Amit Srivastava, Senior Advocate with Girish Pandey.
Yes.
By this writ application, my lord. Your lordship, I kindly see the prayer, my lord. I have requested the lordship, I have prayed your lordship for cancellation of caste certificate of the respondent number 9, my lord.
Cancellation of caste certificate?
My lord, of respondent number 9, my lord. As
for what purpose?
Sorry, my lord.
For what purpose?
My lord, your lordship is aware that, my lord, for giving your lordship, for claiming reservation, my lord, under the EBC category, for a woman candidate, my lord,
So you can file election petition that she is not qualified. How can you file petition?
I am not questioning your lordship her election, my lord.
Then
if your lordship, if I may be permitted to,
you are not then you lack bona fide. You are not questioning her election petition, her election, but you are questioning the caste certificate.
Reason, my lord,
Caste certificate for what purpose?
My lord, caste certificate, my lord, she has not, your lordship, given the caste certificate, my lord, which is required under law, my lord.
Where, which law?
Election.
Which law?
My lord, if your lordship may kindly see, my lord, lecture 6 for a moment, my lord.
No, what grieves you? Why have you filed this application? You want cancellation of caste certificate. Why?
Because, my lord, she has given the caste certificate which is not valid, your lordship, for claiming
For what?
For contesting the election, my lord.
For contesting election.
My lord.
So for contesting election, but you are not aggrieved by her election.
Lord, what I am submitting before my lord is that, my lord, in the state of Bihar, my lord, if your lordship may bear for a moment, my lord.
Yes.
Lord, in the state of Bihar, my lord, so far reservation policy is concerned, my lord, if a female, my lord, is want to, my lord, get a caste certificate, my lord, she has to obtain caste certificate from her parental address, my lord. That is the specific direction as well.
Mr. Rajiv Kumar Singh, you have two options. Either you can go before the election authority or you could have filed election petition. You have come to the High Court.
And where is your prayer for cancellation of the caste certificate? Please read.
My lord, paragraph 1 if I may be permitted to place, my lord, to direct the respondent to produce the caste certificate submitted by Srimati Manju Devi at the time of submission of nomination for the post of Gram Panchayat Raj so and accordingly reject her candidature as she has not submitted the caste certificate issued showing the name of her father.
There is no prayer for cancellation of caste certificate.
My lord.
Make such a submission when there is no prayer in the pleading.
That
is your prayer and that is
This
not your
application lacks bona fide. Not only that, it is not maintainable. It is
incorrect. On the basis of your pleading your submission.
this amounts to abusing the process of the High Court. Why should you come to the High Court? As you wish, we have a duty to decide. We will decide the case.
That liberty may be given the lordship to then before the election authority or the election commission.
Mr. Singh, when counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this writ application with a liberty to take appropriate steps in accordance with law for the redressal of the petitioner's grievances. This application stands dismissed as withdrawn accordingly.
My lords, I am appearing for the state respondents. My appearance be kindly noted, my lord.
I am appearing on behalf of a State Election Commission, my lord.
Yes.
State Election Commission, my lord.
All right.
Oblige, my lord.
Commission. Yes. Next.
Serial number 10. CWJC 20463 of 2021. Srimati Sindhu Singh versus the State of Bihar for the petitioner Mr. Ashok Kumar, Vibhuti Narayan, Anuj Kumar and Kumari Anupam for the Municipal Corporation Shri Ravi Bhushan Verma.
May please your lordships.
Yes.
My lords, the petitioner is the elected chairman of Siwan Nagar Parishad and she is.
May I seek your lordship's permission to mention, Lord, that one IA is also there. We have filed an application, Lord, for intervention for being pleaded as a party. That is.
All right, we will see.
Lordship, in this case, I am appearing on behalf of the state lordship, but a copy of the brief is not available in that. I have not been served upon it.
Let him make out a case first.
Lords.
May please your lordship.
We can adjourn the matter for tomorrow, Mr. Singh. We can adjourn the matter for tomorrow. In the meanwhile, you just serve a copy of the writ petition on London Council for the estate.
Very well, my lords. Very well. Very well, my lords. I'll do so in the course of the day, my lords.
So that if required, he may respond at least for making oral submission.
Very well, my lords. Then tomorrow, my lords.
This matter tomorrow. In the meanwhile, let a copy of the writ application be served on Learned
SC9, Lordship, Kinkar Kumar SC9.
For the state of Bihar.
Obliged, my lords.
Serial number 11. CWJC 6950 of 2021. Akhori Raghavendra versus the state of Bihar for the petitioner Messrs. Amrendranath Verma and Kriti Ranjan for the state Sri Rajiv Roy GP1.
May please, my lord.
Yes.
Lord, there is an interim application, IA application filed by us, my lord. That during pendency, my lord, these petitioners, my lord, are flat owners, and my lord, a sanctioned map by the Nagar Palika of my lord, the Hajipur Nagar Parishad was passed way back in 2011. They purchased the flat, they were living, there are certain grievances. We had made writ application, my lord, making grievances against, my lord, extra sanction, my lord, illegal sanction beyond the building bylaws. But what has happened, my lord, during pendency, that, my lord, the front portion of the eastern portion of the land inside the complex of the flat, my lord, the building, they have, my lord, now they are bringing a wall and making it separate, closing the main entrance of the building. So for the present, we only want, my lord, that further construction may be stopped and, my lord, the matter may be heard at.
But why High Court?
My lord, because, my lord, it is the Nagar Parishad Hajipur.
Who is raising a wall?
My lord, the builder is raising against, my lord, the sanction plan, against the plan sanctioned by Nagar Parishad, they are, my lord, raising the wall.
The builder.
Closing our main entry. Builders, my lord.
Builder.
Builder, my lord.
What are we?
My lord, we are the flat owners, my lord, and we have approached authorities.
What are we? Are we municipal commissioner?
No, not that, my lord. We have approached Nagar Parishad, my lord. We have
You
given
can approach
written.
Nagar Parishad, you can approach SDO, you can approach collector, you can approach everyone. How can you approach the High Court?
My lord, we have approached, my lord, the authorities. They are not, my lord, taking steps.
Where
My
have
lord,
you?
because
Which authority have you approached?
Lordship,
Lord,
there is
Nagar
a
Parishad-
specific rule, Lordship, that is called RERA, Lordship. Real Estate Regulation and Development Act 2016, Lordship, that is
Why are you coming
functioning,
to High
Lordship.
Court?
That
Lord, this is
has been vested with the
2011
power of
2000?
2011 construction, my lord, 2011 sanction, my lord, and the RERA Act has come in 2016.
So
They
therefore,
have
that will
completed
not apply.
My lord,
Therefore, that act will not apply.
my lord.
You have no
They
alternative
have-
remedy.
No, my lord, no, my lord. We have remedy of approaching the, my lord, the respondent Nagar Parishad by way of a complaint that we have done by page 90 of our writ application.
Pursue that.
No action.
Pursue that. Who is for the municipal corporation?
My lord, my
Your
friend is
Lordship,
there.
I appear on behalf of the Nagar Parishad, Your Lordship.
Then you just, where is your representation?
My lord, page 90 of writ application, my lord. Writ application, page 90, my lord. सेवा में श्रीमान कार्यपालक पदाधिकारी नगर परिषद हाजीपुर वैशाली. No sound is coming.
On perusal of the pleadings in the writ application, it is evident that the dispute is between the petitioners who are flat owners of an apartment at Hajipur on the one hand and the builder on the other. So stop. The petitioners allege violation of various provisions in construction of the building in question by the builder of Ashiana Royal Apartment Bagmali, Sachi Patti, Hajipur, bracketed Vaishali. Stop. Next, it is stated in the writ application that the petitioners have approached the executive officer, Nagar Parshad Vaishali, Hajipur, Vaishali in January 2021, but no remedial measures have so far been taken. Stop. Next, Mr. Ankit Kataria, learned counsel for the Nagar Parishad.
Yes, Hajipur Nagar Parishad, Your Lordship.
Hajipur Nagar Parishad is present. Stop. Considering the facts and circumstances of the case, this application is disposed of with direction to the which respondent?
Chief Executive Officer, my lord.
Number 10.
Respondent number 10, my lord.
Consider the petitioner's grievances as raised in the said representation dated 2021, a copy of which has been brought on record by way of annexure.
Annexure 7, my lord.
Annexure 7 to the writ application, and take a decision and take appropriate action if required in accordance with law as expeditiously as possible. Yes.
Serial number 12. PWJC 17873 of 2021. Messrs. Express Food Service through its partner, namely Sivakant Pandey versus the Union of India, for the petitioner Messrs. Satyam Shivam Sundaram and Bikash Kumar, for the railway Sri Ramadhar Shekhar, for the private respondent Senior Advocate Sri Devendra Kumar Sinha.
Lordship, I am for petitioner. There are 3 cases, and in third case, Your Lordship, I have received a copy of counter affidavit by railway in the evening. Lordship, so for filing rejoinder, a short time may be granted and may be taken up on Monday. In the meantime, I will file rejoinder.
Which CW, which case number?
CWJC 18834 public 2021. There are 3 cases listed together at
State
serial.
Learned counsel appearing on behalf of the petitioner in WJC number 18834 of 2021 that a copy of counter affidavit has been served upon him recently, which he requires to consider and file a rejoinder if so needed. First off, as requested, list these matters on when?
Monday. Next
Monday.
month. Obliged.
Yeah. Yes.
Gaylord. Serial number 14. PWC 6724 of 2020. Sateswar and Jyoti versus the state of Bihar, for the petitioner Mrs. Mahasweta Chatterjee, for the Religious Trust Board Sri Ganpati Trivedi Senior Advocate.
Yes, ma'am.
Yes, my lord.
My lord, in
I am
this case,
appearing in this case on behalf of the petitioner, my lord. Initially, my lord, this case was filed for quashing of Annexure 12 and 13, and now
it
during
appears
the Annexure 12 and 13, now during the pendency of the writ application, the Chairman Religious Trust Board has amended the earlier order of constitution of committee by another notification, for which I have filed an IA petition, IA number 1. I have filed that IA on 10/12/21. That is, I have annexed that amended notification as annexure 23 to that IA petition, my lord.
Yes.
By annexure 12, my lord, the Chairman Religious Trust Board constituted a committee under section 32 of the Act without actually removing the petitioner from the post of trustee. And now, my lord, after the counter affidavit has come, it has become an admitted position that the petitioner was appointed as the Mohant of the trust in question, my lord. And now thereafter, after taking charge of the Mohantship, he found that total property of the Math is encroached. Therefore, he wanted to file an encroachment case before the tribunal. Therefore, as per the provision of section 43, he filed a sought permission from the board, and thereafter, after the expiry of 88 weeks, he filed that petition before the tribunal for removal of the encroachment, impleading 195 villagers as party, as encroacher. And when the notice was issued in that encroachment case, some of the encroachers who appeared after receiving the notice filed a complaint petition against the petitioner, my lord, that he is misusing the property, etc., etc. Then notice has been issued. Petitioner was directed.
You are challenging an order, madam. Are you challenging an order? What are your reliefs?
Initially I filed this case for quashing of annexure 12.
So that has been amended.
That has been amended by annexure 23. That is page 9 of the IA petition.
So you could have filed a separate petition. Why amendment?
Continuation, may I read that amendment petition?
All right. All right. Where is that?
That has been amended. My lord.
Where is annexure 23?
That is as annexure with IA number 1/21 at page 9 of that IA petition.
You are challenging annexure 22.
23.
23.
G. It is with IA number 1.
IA number 1 is there. IA number 1 of 21 is there.
IA number 21. Yes, it is IA number 21.
Yes, 23.
IA number 21. That is, your lordship will find from this that it is a continuation. And Sri Ekshwar Hareshwar Nath Math, Bhatora Math, ग्राम पोस्ट भतौरा जिला हिंदू धार्मिक अधिनियम धारा 34 के अंतर्गत परिषद में निबंधित एक सार्वजनिक मठ है, जिसकी निबंधन इतना है: न्यास के सुचारू प्रबंधन, संपत्तियों की सुरक्षा एवं संरक्षण तथा समग्र विकास हेतु परिषद अधिसूचना संख्या 961 दिनांक 25/9/19 द्वारा एक न्यास समिति का गठन 5 वर्ष के लिए किया गया था. Initially, this order was challenged, which is annexure 12. उक्त न्यास समिति के कोषाध्यक्ष श्री राम बहादुर मंडल के संबंध में पार्षद को सूचना प्राप्त हुई कि थाना कांड संख्या इतना जिसका जीआर इतना है श्री राम बहादुर मंडल साजाफ्ता है, जिसके विरुद्ध पटना उच्च न्यायालय में अपील बात संख्या इतना अभी भी विचाराधीन है। इस संबंध में राम बहादुर मंडल द्वारा अभी तक स्पष्टीकरण समर्पित नहीं किया गया है। महंत श्री सत्येश्वरानंद ज्योति द्वारा लगभग 196 व्यक्तियों के विरुद्ध अतिक्रमण बाद बिहार हिंदू धार्मिक न्यायाधिकरण में दाखिल किया गया है, जिसका बात संख्या 3 इतना है, अभी तक विचाराधीन है। पार्षद के पूर्व आदेश दिनांक 6/12/18 द्वारा उन्हें मठ की संपत्ति के संबंध में विचाराधीन बाद में पैरवी करने, मठ को और अपना पक्ष रखने एवं अन्य पदाधिकारियों के समक्ष आवेदन देने के लिए प्राधिकृत किया गया है। उक्त कार्य के समिति आवश्यकता अनुसार उपलब्ध कराएगी। अतः न्याय समिति परिस्थितियों पर पुनर्विचार करते हुए परिषदीय आदेश संख्या दिनांक 2/8/21 के आलोक में परिषदीय अधिसूचना संख्या 961 डेटेड 25/9/19 को संशोधित करते हुए उक्त अधिसूचना के वर्णित नियम शर्त के अनुसार निम्नलिखित सदस्यों की संशोधित न्याय समिति कार्यरत रहेगी। These are the persons, my lord. Now, my lord, I want to draw your lordship's attention to annexure 8 at page 130.
Now, how is this order illegal according to you?
Yes. Number one, I have stated in my supplementary affidavit, all the petitioners, all the members are facing criminal case. All the petitioners excepting one. And Ram Bahadur Mandal, who has been
whom?
Excepting number one.
Accepting number one.
Number one is petitioner.
Yes,
There
yes, we understand, madam.
Madam, I have stated, madam, kindly see.
So where is the requirement? Where is the requirement that if someone is facing criminal prosecution, he cannot?
Yes, that is. Yes, yes, my lord. And not only that, my another submission also. I will come to that, my lord. I will meet up your lordship's query. My lord, another submission is that all to the knowledge of the board, all the members are the encroachers, and they have been pleaded as party in encroachment case number. And under section 43 of the act, it is the board, or with the permission of the board, encroachment case can be an encroachment for removing encroachment case can be filed before the tribunal.
So
And
can they decide the encroachment cases?
Tribunal can decide it under section 48. May I read it, my lord?
All right, but these members.
Section 43.
Madam, the members cannot decide encroachment cases. If the encroachment cases are pending, encroachment cases will be decided against them. Can be decided against them. Can be decided in their favor.
Yes, my lord. My submission is that there is no dearth of citizen. Number one submission, that there is no dearth of religious minded person in the village. And on the complaint filed by the encroachers, after receiving the notice, the committee has been constituted.
No, madam, the best way is that if you file encroachment cases against all the persons whom you want not to become members of the committee, you will be happy. You can take a plea that encroachment cases are pending. I have filed encroachment cases against all the persons, and therefore this person should not be there. This person should not be there.
Well, unfortunately, the encroachment case is of the year 2016, and the complaint has been filed after issuance of the notice by the encroachers, and thereafter all the steps have been taken by the board.
Law will take its own course. Where is the provision that if a criminal case is pending against someone?
Yes, section 28, madam. Section 28.
Just.
Before my lord takes a decision, my lord, may I point out one thing, my lord?
Please wait.
Section 28, my lord.
Section 20.
I have got many other points also, my lord.
Where is the provision that if some
yes, 28 to H.
this speaks of conviction?
No, not only Ram Bahadur Mandal is convicted.
Therefore, he has been removed.
No, he has not been removed. He has only restrained from working.
Yes, he has been noticed.
Noticed, and he is not yet been removed. Though the board has
He
got
has been noticed. His appeal is pending. He has been noticed.
Now, my lord, may kindly see
22H1.
1. Kindly see, I have got other points also, my lord.
These applications are simply abuse of the process of the court.
No, my lord. Then, my lord, my submission, another submission maybe.
Make your submission. This is our tentative opinion. You have taken absolutely incorrect plea that because criminal cases are pending, they could not have been made members. Because encroachment cases are pending, therefore they could not have been made members.
Yes, because, my lord,
these are your main points.
Kindly allow me to place section 28.
Madam, we will allow you to argue till 4. We will not stop you from making submissions.
No, my lord, kindly allow me.
This is litigation before the High Court.
My lord, I hope that I'll be able to convince your lordship.
Yes.
I hope and trust it.
Yes,
My lord,
but we also assure you, madam, we also assure you that if finally we are not convinced, we will be imposing cost exemplary.
No. My lord, we kindly come to section 20.
Not only your time and the court's time, it is the public time which is being consumed.
But it is, my lord, it is our duty to try to convince your lordship.
Therefore, we are not stopping you. And whatever view we have expressed, those are just tentative, not final. If you can convince otherwise, it's a different matter. But if we are not convinced, we will be imposing cost.
I'll not waste your lordship's time, my lord.
We are tentative.
I'll not waste much time of your lordship.
Yes.
Kindly allow me to 5 to 10 minutes, my lord.
There is no question of allowing you. We are stopping ourselves from making our observations anymore. We give you time. Make your submissions.
My lord, kindly come to section 28(2)D. Section 28(2)D speaks that to take measures for the recovery of lost property of any religious trust. It is the duty of the religious trust. It is the duty of the religious trust board to recover the lost property. Now, my lord, when the enforcement case is filed, then it will be deemed that board has filed this enforcement case for removal of these members, my lord. Therefore, they should not have been appointed as the members. They cannot work in the interest of the board. Not only that, my lord, I have stated in my IA petition, my lord, that they have started misusing the property of the board, and there is a complaint petition filed against them. And the case is pending. They are cutting the trees and they are selling it and misappropriating the sale proceeds. And my submission, without wasting your lordship's time, that all the orders have been passed by the chairman himself.
Yes.
Am I audible, my lord?
Yes.
My lord, all the notification as contained in Annexure 12 and 13 was issued on behalf of the chairman alone. At that point of time, there was no board, and after the board also has been constituted on the 2nd of January 2021, the amendment order has been issued by the chairman alone. No,
Yes.
without the consent of the board.
Yes. Yes, Mr.
And I have filed a supplementary affidavit yesterday, my lord, stating this fact. Then it is the chairman alone who has issued the amendment order, my lord. And it is the power of the board under section 32 to constitute a committee. And board chairman, after the constitution of committee, full-fledged committee, the chairman could not have exercised this power.
Yes. Yes, Mr. Trivedi. Mr. Trivedi.
Shri Ganpati Trivedi.
Mr. Ganpati Trivedi, he is.
My lord.
Yes.
My lord, first, my lord, this order is this against that remedy lies before the district judge, my lord. If a committee is constituted under section 32, then subsection 3, my lord, provides for raising grievance. The trustee are permitted to place subsection 3 of section 32, my lord. The trustee of or any other person interested in such trust may within 3 months of the date of publication in the official gazette of the scheme so settled, modified or substituted instead of another scheme, as the case may be, may make an application to the district judge for varying, modifying or setting aside the scheme, but subject to result of such application, the order of the board under subsection 1 and 2 shall be final and binding upon the trustees of the religious trust and upon every other person interested in the religious trust. So she could have challenged before the district judge. Number 1, as regards the power of the president is concerned, my lord, under section my lord, under section this bylaw have been framed, my lord, under the act, under the provisions of the act. Board has framed bylaw and aside, my lord, under bylaw 43, regulation 43 of the bylaw, my lord, it will be at page 97 of the same book, my lord, if it is.
Yes.
My lord, that talks about, my lord, the powers and duties of the board prescribed below shall be exercised and performed by the president. My lord, so got it.
Yes.
Section the regulation R, the 43R, my lord, to settle schemes for proper administration of the religious trust. Then, my lord, may come to Z5, my lord. The next page, my lord. Z5 may constitute a trust committee under section 32(1) of the Act.
Yes.
My lord, that bylaw have been framed under section 81 itself. My lord, may come to section 81 of the Act. 82 of the Act. No, so sorry, my lord. That is power 83, my lord. Section 83, power of the board to make bylaws.
Yes.
There are under different. My lord, will come to 83K. The allocation of duties to the president and members. Then, my lord.
For reading 83.
My lord, 83K. K. The subject matter over which the bylaw can be framed.
Yes.
That bylaw 43 has been framed under this statutory power under section 83, my lord. And that bylaw, my lord, is, my lord, such bylaws shall be, if my lord come to subsection 3 of section 83, my lord, such bylaws shall be made after previous publication and shall not take effect until they are approved and confirmed by the state government. Provided that if the state government do not approve and confirm such bylaws within 4 months from the date and receipt thereof, by the state government, the said bylaws shall be deemed to have been approved and confirmed on the expiry of the said 4 months. My lord, these bylaws, amended bylaws, all the bylaws have been duly notified and approved by the state government. So it has got a statutory force. Exercising that power under the act, under the bylaw, the president exercises its power, and ultimately when the states are, my lord, this decision is taken by the president, they are ultimately produced in the meeting, in the regular, in the meeting held by the full, my lord, meeting of the board. They are approved there. So, my lord, it cannot be said that the board president has no power to constitute a committee.
Yes.
Yes.
Even the earlier judgment, the previous judgment, Justice, Honorable Justice Shivaji Pandey, as then was, my lord, he had passed the orders that president cannot pass any order since the board had not been constituted, because the president has to be appointed out of the members of the under section, my lord, section constitution of the board under section 8.
No, Mr. Trivedi, your submission is that there cannot be a board only with someone as the president. The president can be of the board. And unless the board is constituted, there can be no question of existence of any person as other the president.
My lord.
Once a board is constituted, once the board is in existence, the president can exercise such powers which are vested in him in accordance with the bylaws. This is your submission.
My lord. So now the board is constituted on 2nd January 2021. He has taken a decision. He has constituted a committee under the power vested in him under the law. That is amenable if at all she is agreed. She can go before the challenge before the under section 28(3), because this 32(3). So the writ is not maintainable. That is my submission, ma'am.
32(3). Let me see.
Because there is no dispute that committee is constituted under section 32.
This power has been exercised under subsection 2 of section 32.
My lord. Subsection 1, my lord.
Subsection 1. Yes. So, charger.
Lord. May I give reply, my lord?
Charger is coming.
May I reply to
in fact. Madam, my system is getting discharged. I will join again after some time. After 5 minutes.
All right, fine.
जी
तब हुआ कुछ से साहब कौन सा सीरियल चल रहा है क्या सीरियल चल रहा है
हाँ मनोज जी, कौन सा सीरियल चल रहा है? कौन सा सीरियल हो रहा है?
प्लीज वेट तो कीजिए सर, नहीं अगर कुछ बात कर पा रहे हैं आप लोग से साथ तो
सीरियल तो बता
आप लोग
देते
तो
कम
सर
से कम।
प्लीज हम फर्स्ट अकाउंटेबल हैं सर बिफोर लॉर्डशिप। आप लोग तो ऐसा करने लगते हैं ना सर, हम उनको अटेंशन नहीं पे करें, आपके क्वेश्चन पे इमीडिएट कॉल बैक कर जाएं। ऐसा हम लोग नहीं देखे सर अपने बार को।
गुस्सा होता है।
गणपति बाबू कौन से सीरियल में अपीयर किए थे? आए? आवाज नहीं आ रही।
14.
14, थैंक यू। अभी कंटिन्यू चलेगा ना आपका?
कंक्लूड ही हो रहा है।
कितना चल रहा है अभी सीरियल नंबर त्रिवेदी जी?
14.
Oh, thank you.
चार्जर लगाना है बता नहीं। फोन फोन हाँ, वो हमारा हम लैपटॉप लेके बैठे हुए थे, कोर्ट में बैठ गए थे, वहाँ चार्जर था नहीं। हाँ ठीक है।
जी लॉर्डशिप।
Yes, Mr. Yes, madam, you wanted to say something in reply?
Yes, my lord. I want to reply to his argument, my lord.
Yes.
My lord, now his first argument is that there is an alternative remedy under section 32(3) of the Act, my lord. In reply, I will say that admittedly, it is a well settled principle that when the order is palpably illegal and in violation of principle of natural justice or without jurisdiction, an alternative remedy is no bar. That is my reply. I'll show before your lordship when initially the Annexure 12 was passed, constituting the committee, that is 25/9/19, there was no board. And admittedly, board has been constituted on 2nd of January 2021. And thereafter also amendment order has been issued. But this is my definite submission before your lordship's consideration that the amendment order also, as contained in Annexure 23, also has been issued by the chairman himself. And I have filed a supplementary to this effect yesterday, my lord.
All right, we'll call for the supplementary affidavit.
Yes, my lord, my second reply to the submission of Mr. Ganpat Trivedi is that this point was earlier considered several times. The bylaws number 43R, my lord. A case reported in 2000 volume 4 PLGR page 645, my lord. Paragraph number 4 and 5, my lord.
Yes, what has been held?
They held that, my lord, held that it is the under by clause 43 of the bylaws framed under the act only gives power to the president to advise, opinion or direction to a trustee regarding management of administration of the property of the trust. Such a power does not include the power of removing the trustee or exercising the power of the board, my lord. That is the paragraph 4 and 5, my lord. My lord, may kindly see the power.
So have you been removed?
Petitioner, my lord.
Have you been removed?
That is also my one of the submission. That is why I was drawing your lordship's attention to page 130, the annexure 6.
You are relying on a judgment which refers to the power of the chairman vis-a-vis approval of.
Yes, my lord.
So you have not been removed.
Yet, on that, my reply will be, my lord, my submission will be the power which can be exercised by the board. That is the interpretation. Either it is under section 28 or it is under section 32. That is my submission. Number one. Number two, that by an order dated 6/12/18, whoever is the trustee has been removed. Thereafter, the committee has been constituted. Therefore, I was drawing your lordship's attention to page 130, by which an order that is an order passed by the administrator removing the trustee. And and my lord, my learned senior friend has argued before your lordship that the board has approved the amended order. Let him bring all this approval meeting in reply to my supplementary affidavit. I have stated definitely in my supplementary petition that the board it is passed by the chairman alone, not by the board.
It is not his submission that the order has been approved. It is his submission that the bylaws framed have been approved by the board.
Yes,
and
for that I have placed the 2000 volume 4 PLGR, my lord. That is, kindly allow me to place paragraph number 4 of that decision, my lord.
Yes.
It is not disputed before us by the learned counsel for the respondent board that the power to remove the trustee vests in the board itself. That is not only confined to removal only, it is with regard to the power of the board. under section 28H of the Bihar Hindu Religious Trust Act 1950. However, under section 38 of the said act, where immediate action is called for and it is not possible to convene a meeting of the board, the president may exercise any power that could be exercised under the act by the board. This is, however, subject to the condition that the president shall at the next meeting of the board report in writing of the action taken by him and his writing of the action taken by him under this section and the reasons for taking such action for confirmation of the action taken. Section 39 speaks about the delegation of the power to the president. My humble submission is that for exercising the power of the board by the chairman alone, there was no such urgency. Neither it has been confirmed by the board in the next meeting. Neither the power has been delegated as contemplated under section 39 of the Act to the president by the board as yet. Therefore, any order passed by the chairman alone is illegal, without jurisdiction and fit to be set aside.
Third learned counsel for the petitioner and learned senior counsel appearing on behalf of the Bihar
Hindu Religious Trust Board.
Bihar State Board of Religious Trust.
Bihar State Board of Religious Trust.
Of Religious Trust. Stop.
I am for the state, my lord. I am for the state, my lord.
At length, and counsel for the state is also present. Stop. And counsel for the petitioner has informed that a supplementary affidavit has been filed yesterday So stop. Referring to the said supplementary affidavit, arguments have also been advanced. So stop. List this matter tomorrow along with the said supplementary affidavit.
My lord, one thing I wanted to say, my lord, the judgment which has been referred to, that was regarding removal of the trustee, and the power of removal has not been vested by the under any of the bylaws to the president, and that's why the order was set aside on this score itself.
No, no.
Tomorrow we will decide.
My lord.
Let the affidavit come. We want the affidavit to be there on record.
Serial number 15. CWJC 9671 of 2020. Indra Mohan Singh versus the State of Bihar. For the petitioner, Shri Sanjeet Kumar. For the state, Senior Advocate Shri Ajay Kumar Rastogi, ASG 10. For the private respondent, Anukirti Jaipuriyar, Ajay Kumar, and Shailendra Kumar Singh.
Milords, as Mr. N.K. was senior advocate, has to appear, Milord. He is not ready, Milord. So kindly 1 week time may be granted. Monday, Milord.
As requested on behalf of the petitioner,
Lordship, appearance can be made of BSFC.
the ground of non-availability of learned senior counsel. Matter on 1 week.
Monday, Milord, Monday.
Counsel for the Monday. Learned counsel for the state is present. State or BSFC?
BSFC, Shailendra Kumar Singh.
Appear for the state, my lord.
Are you Shailendra Kumar Singh?
Lord Sahib, I am junior counsel to Shailendra Kumar Singh.
Learned counsel for the BSFC is present.
I appear for the state, my lord. AC to AG 10, my lord.
Yes, next.
Serial number 16. CWJC 9937 of 2020. Satyendra Kumar Singh versus the State of Bihar. For the petitioner, Sri Avdesh Kumar Singh. For the state, Sri Ajay GFI.
My lord, in this case, my lord, I am appearing on behalf of the petitioner, my lord. My lord, may kindly see the last order dated 17/12/2020, 2021, by which 2 weeks time was granted to the state, my lord, to file counter affidavit in this matter.
The orders of this court dated 17/11/2021 and 17/12/2021 requiring the state of Bihar to file counter affidavit have not been complied with. So now, list this case on 2 weeks. So stop. In the meanwhile, the respondent shall be obliged to file a counter affidavit after depositing a sum of rupees 10,000 as cost in the account of Bihar State Legal Service Authority. Stop. If no counter affidavit is filed on the next appointed day, on the next date fixed for this matter, comma, the district magistrate Chapra shall be required to be personally present.
Much obliged.
Serial number 17. CWJC 678 of 2021. Pankaj Kumar Gupta versus the State of Bihar through the Secretary. For the petitioner, Mr. Sanjeet Kumar and Preeti Kumar. For the state, Sri S. Raza Ahmed, AAG5.
Lords, as I have received counter affidavit on 15/12/2021, my lord, and client could not be able to come, my lord. So kindly 10 days may be granted to file rejoinder, my lord.
As requested on behalf of the petitioner, 10 days time is allowed to file rejoinder the counter affidavit filed on behalf of the respondents. So stop. List this case 2 weeks.
Much obliged, my lord.
Serial number 18. CWJC 4394 of 2021. Syam Sundar Prasad versus the State of Bihar. For the petitioner, Mr. Sasi Bhushan Kumar Manglam and Avnish Kumar. For the state, Sri Yogen Prasad Sinha, AG7. For the municipal corporation, Mr. Rajiv Ranjan Kumar Pandey and Sanjay Kumar Tiwari.
But this matter was heard on the last occasion, but the hearing could not be concluded. So I would like to seek adjournment for the day in this matter so that I can transmit the list of citations to the court master today itself for its hearing on tomorrow.
As requested on behalf of the petitioner, list this matter tomorrow.
Obliged.
I'm appearing on behalf of respondent, your lordship. My name is not appearing.
Which respondent?
I am for the statement.
Which you are appearing for which respondent and why is your name not appearing?
Yes, my lordship. In the list, it is appearing, but the order sheet, it is not, your lordship. Last two occasion, your lordship.
All right, it will appear.
I'm obliged, your lordship.
You are appearing for which Mr. Sanjay Kumar for whom?
Panchayat Secretary, your lordship.
Panchayat Secretary.
Yes, your lordship.
He has engaged another council, different council, other than state council.
My lord, I am for the so far the my lord, municipal corporation is concerned. For that, my friend is going to be appeared, my lord.
I am for the lordship.
Number 7, Milord, Sir Rajiv Ranjan Kumar Pandey.
Send your slips. Send your appearance slip.
Obliged, my lord. I'm out.
Serial number 19, TWJC 4625 of 2021. Kameshwar Prasad Srivastava versus the State of Bihar for the petitioner Sri Prashant Kashyap for the Municipal Corporation, Senior Advocate Sri Vindhyachal Singh for the estate Sri Rajiv Roy GP1.
May I please, Lordship?
Before, Lord, the counsel for the petition begin, Lord, may I pray, Lord, 2 weeks more time, Lord. I have received the statement of facts. Lord, I'll be filing counter affidavit. Lord, within a week, Lord, it may kindly be taken
Who is
off.
for the petitioner?
I am for the petitioner, Lordship.
I'm for the state, Lordship.
By way of one week time, not more than 1 week. Twice time was granted. 1 week time is allowed for the Patna Municipal Corporation. 1 week further time is allowed for the Patna Municipal Corporation to file counter affidavit. List this case on 1 week.
Public.
Serial number 20, CWJC 5040 of 2021. Dr. Dev Narayan Bhagat versus the State of Bihar for the petitioner Mrs. Mashum Alam, Suraj Narayan Yadav and Anil Kumar. For the state Sri GT1 Rajiv Roy. For the Municipal Corporation Sri Vijendra Kumar Singh and Mayank Rukhiyar.
May please, Lord. I am appearing for the petitioner, Lord. My Lord, the petition has been filed, my Lord, with a prayer to restrain the respondents in interfering in any way in construction the building over his land, my Lord, and further to quash the notice dated 28/9/2020 issued by respondent number 3. That notice first may kindly be seen, my Lord. It is annexure 6, page 29. My Lord, annexure 6, page 29. May I read it, my Lord? प्रेषित स्वयं विषय इस कार्यालय के पत्रांक 619 दिनांक 21/4/2016 दिस इज एनेक्सर 2 में दर्शाए गए तथ्यों के विपरीत कराए जा रहे निर्माण कार्य को अविलंब रोकने के संबंध श्री महेश श्रीवास्तव कालीबाड़ी चौक वार्ड नंबर 22 भट्टा बाजार पूर्णिया द्वारा एक आवेदन समर्पित करते हुए जानकारी दी गई है कि आप वर्तमान में मौजा मधुबनी थाना स्वयं अवस्थित एमएस खाता नंबर इतना खेसरा नंबर इतना गांव में खरीदगी 5 कट्ठे भूमि पर स्वीकृत नक्शे से हटकर वर्तमान में निर्माण कार्य कराया जा रहा है। शिकायतकर्ता के द्वारा यह आरोप लगाया गया है कि आपके द्वारा शिकायतकर्ता के घर जाने वाले आम रास्ते के पश्चिम दक्षिण कोने पर 9 इंच जबकि उत्तर पश्चिम के कोने पर 10 फीट 4 इंच चौड़ाई में तथा 34.4 इंच जमीन पर उत्तर दक्षिण की लंबाई में पक्का निर्माण कर लिया गया है। इस दरमियान आपने उत्तर की तरफ नवनिर्मित पीसीसी सड़क की तरफ न सिर्फ अनाधिकृत रूप से 2 द्वार खोल लिया गया है बल्कि सड़क की ओर कई छज्जों का निर्माण भी कर लिया गया है। साक्ष्य स्वरूप निगम कार्यालय से निर्गत कारण परीक्षा दिनांक 21/4/16 एवं अद्यतन फोटोग्राफ इस पत्र के साथ संलग्न किया जा रहा है। अतः आप नोटिस प्राप्त करते ही आगे का निर्माण कार्य बंद करते हुए शिकायतकर्ता द्वारा उठाई गई आपत्ति के संबंध में अपना साक्ष्यों पर आधारित पक्ष और हस्ताक्षरी के समक्ष दिनांक 5/2020 के समक्ष रखना सुनिश्चित करें। This notice is under challenge, my lord. Now, my lord, come to annexure 2, page 14. It is at page 14, my lord, annexure 2. Notice has been given, my lord. According to this notice, the petitioner had purchased the 5 kattha land.
Mr. Suraj Narayan Yadav, you were just asked to go before the municipal commissioner and explain. You could have gone there and explained.
Yes, yes, this is my grievance, my lord. This is Annexure 6, my lord. This is dated 28/9/20. On my lord, I represented by Annexure 7 on 29/9/2020. And my lord, I have written everything, given every explanation. My lord, kindly give me, my lord, only 5 minutes time. My lord, the first notice was issued, my lord, to this petitioner, my lord, wide Annexure 1. That is, my lord, dated 10/3/2016. I submitted so cause. Then, my lord, they issued Annexure 2, that is 21/4/2021, page 14. I filed so cause, and that is my so cause is Annexure 3, page 16. I filed it. Thereafter, no action was taken, no any order was passed. My building construction work was stopped. Then, my lord, I moved before the municipal commissioner, and my lord, by my lord, find from Annexure 4, page 24. On my representation, a team was constituted of 3 persons, that is Prabhari Kani Abhiyanta Nagar Nigam, Prabhari Bhavan Manchitra Nagar Nigam Purnia, and Anchal Amin Purnia. They have measured the land and submitted report Annexure 4. According to that, I have constructed my house over 3.5 kattha land out of 5 kattha. And they are saying that though land he has purchased is 5 kattha only, but it constitutes 6 kattha due to map or anything maybe. But this report will show, my lord, that I have not did anything. My lord, may I read it, my lord? संदर्भित कार्यालय नगर निगम पूर्णिया के पत्रांक 524 दिनांक 22/6/18 एवं अंचल अधिकारी पूर्णिया पूर्व के ज्ञापांक इतना के आदेशानुसार श्री जनार्दन प्रसाद रजक प्रभारी कनीय अभियंता नगर निगम पूर्णिया, श्री उमेश प्रसाद यादव प्रभारी भवन मानचित्र नगर निगम पूर्णिया के साथ निर्धारित दिनांक 27/8/18 को 2:30 अपराह्न में उपरोक्त विषयांतर डॉक्टर DN भगत पिटिशनर है, पिता स्वयं न भारत अस्पताल लाइन सोयनसो पूर्णिया के 4 केवाला द्वारा खरीदी गई 5 कट्ठा जमीन नगर पालिका सर्वे वार्ड नंबर सोयनसो, नया वार्ड नंबर सोयनसो, खाता नंबर सोयनसो, खेसर नंबर सोयनसो खरीद की गई है। खरीदी भूमि के अंतर्गत अनिर्मित पक्का मकान का नापीकर भवदीय द्वारा संयुक्त प्रतिवेदन समर्पित करने का आदेश दिया गया है। आदेशानुसार संयुक्त रूप से पक्का निर्माण कार्य निर्मित का मापी किया गया। मापी के क्रम में पाया कि अर्धनिर्मित मकान पक्का मकान का मापी उत्तर 104 फीट 11 इंच, दक्षिण 102 फीट 8 इंच, पूरब 32 फीट 3 इंच, पश्चिम 30 फीट 9 इंच है। कुल 3269 3269.7 वर्ग फीट रकबा लगभग 7 डिसमिल 506 वर्ग कड़ी अर्थात लगभग 3.5 कट्ठा जमीन के अंदर अर्धनिर्मित मकान है। प्रतिवेदन के मूल में संलग्न टेस्टनर अर्धनिर्मित भवन के शिलान्यास एरिया दिस हैज बीन सबमिटेड ऑन 25/7/18. No action taken, my lord. Then I submitted representation, my lord, which is Annexure 5, my lord. Annexure 5. My lord will find my representation, my lord, at page 27. I filed it on 9/7/2018. Thereafter, they slept over the matter. Nothing was done, my lord. And then, after 2 years, more than 2 years, they issued Annexure 6. No final order they have passed, my lord, as required under the Act, my lord. If I was committed any deviation, then they have to pass a final order. But that was not done. And after receiving this notice, Annexure 6, I submitted my representation. And
Has been denied.
My lord.
Your statement has been denied. You did not respond to the notice.
No.
This is the stand taken in the counter affidavit.
My lord, kindly see it, my lord. They are saying they have to move before the.
That is one aspect. That is one aspect of the matter. The other aspect is, and the copy of your reply dated 28/9/2020 is undated. When this reply was received by them, it is not mentioned.
My lord, paragraph
Just a copy of
25
some.
of the. My lord, paragraph 25 of the counter affidavit, my lord.
What?
I made it. That so far the statement made at para 16 and 70 of the writ are concerned, it is humbly and respectfully submitted here that since 21/4/16 till 28 which the petitioner himself prepared petition and so, they are saying about the, I move before the district grievance redressal cell, who do not have any, there is no specific denial of that statement, there no such annexure 7 petition dated 29.
We will have to show you. Come to paragraph 13 of the counter affidavit.
My lord. That the petitioner, without giving his reply of notice dated so and so, approached before this honorable court. My lord, they are saying so. Yes,
They
my
are
lord.
saying
But my lord, it is submitted by me, my lord.
it is submitted by me, it is not submitted by you. That is not incontroverted.
My lord, they are denying this is there. But my lord, I filed this petition. If my lord, his view is taken that they have, I have not submitted such so cause, then my lord, they should have considered this so cause and pass a final order. Copy has been given to them. Everything was given to them.
You are taking a false plea and they should decide your representation.
My lord, I am saying that
You are do you have copy of your of annexure 7 in your petition, in your copy of the writ petition?
It is annexure 7, my lord, at page 30.
Annexure 7 at page 30.
My lord.
Where is the signature of the petitioner? Where is the date? No date given.
It is the copy, my lord, typed copy.
Typed copy.
Which is with me, my lord, and which I have annexed, my lord.
The petitioner in the present writ application.
My lords, I'm sorry to interrupt. I have filed an IA application for intervention as responding. This is the only thing I wanted to point it out. The lords dictate the order.
The petitioner has put to challenge a communication dated 28/9/2020 issued by the Municipal Commissioner, Purnia Municipal Corporation, whereby acting on a complaint received in respect of illegal construction being made by the petitioner, he has been asked to explain before before him and restrain the petitioner from making further construction. So, next. Upon perusal of the impugned communication dated 28/9/2020, it is evident that the petitioner was merely asked to explain his position in respect of complaint made regarding illegal construction being made by him comma, by 5/10/2020. First off, next. Though it is stated in the petition that the petitioner had immediately filed a representation in response to communication dated 28/9/2020, comma, the same has been specifically denied in the counter affidavit filed on behalf of the corporation. Stop. The corporation has also taken a plea that the petitioner has alternative remedy of approaching the Bihar Building Tribunal. Next. Mr. Suraj Jadhav, counsel appearing on behalf of the petitioner has submitted that earlier also a so-called notice was issued to the petitioner in 21/4/2016, which was duly responded to. First off, the corporation, without passing a final order on the petitioner's reply to the so-called notice, comma, issued another notice, another impugned notice dated 28/9/2020. So he reiterates that the petitioner had submitted his response to the notice dated 28/9/2020 on 29/9/2020. Next. There being a specific denial by the corporation that the petitioner did not file his explanation before the municipal commissioner pursuant to communication dated 28/9/2020, which has remained uncontroverted, comma, we are not inclined to accept the said contention of the petitioner. Next, we, in our opinion, comma, this writ application filed on 12/2/2021 was premature. First off, next, it will be open for the petitioner to take recourse to remedy either by responding to the said communication dated 28/9/2020 before the municipal commissioner or by approaching appropriate authority in accordance with law. First off, this application stands dismissed.
Milord, 1 minute, Milord. I am interfering. One mistake has occurred, Milord.
Yes.
Milord, I am sorry. I am sorry, Milord.
Just a minute. Just a minute. An intervention application has been filed in this case, registered as IA number 1.
IA number 1, my lord.
1 of 2021, which stands disposed of. Yes, Mr.
My Lord, Section 325(4) of the Act provides a stoppage of building or work in certain cases. And against that, my Lord, subsection 5 says, no court shall entertain any suit application so and so. So far, building tribunal is concerned, my Lord, that is provided, my Lord, jurisdiction is there. If order is passed, my Lord, order of demolition under Section 323 and Section 323 of subsection 3 says a person aggrieved by an order of chief municipal officer under subsection 1 may within 30 days prefer an appeal against the order to the municipal building tribunal. So, my lord, that submission made by...
The court is not compelling you. The court is not compelling you. The court has just observed. You may take, you may not.
My lord,
if that is not permissible, you don't do. If
I only pointed out such things so far, my lord, they have said
It is there in our mind, Mr. Yadav. When we pass orders, there are so many things in our mind. We just allow the things to remain open for you to take recourse.
वो जो डिसमिसल लिखा दिया गया है उसको dispose of कर दिया गया मुझे
No, dispose of, we cannot interfere. Your application was premature. This is what we have observed.
that my lord had said premature, so dispose of कर दिया जाए. वो जो dismissal word will be. My lord, it is my prayer.
Sorry, Mr. Yadav.
Serial number 21. CWJ 5470 of 2021. Sambhu Singh versus the Union of India for the petitioner Mr. Suraj Samdarshi and Ranjit Kumar for the
Your Lordship,
Union of
Senior,
India for the state Sri Bikash Kumar SC 11 for the private respondent Sri Kumar Priya Ranjan and Revati Kumar Raman.
Your Lordship, Senior Counsel Mr. P.K. Sai has to assist the case. Therefore, I pray for a passover.
As requested on behalf of the petitioner, list this matter on tomorrow.
Obligement.
Serial number 22. CWJC 5659 of 2021. General Manager versus the Chief Managing Director for the petitioner Sri Abhinay Raj for the Electricity Board Sri Akhleshwar Singh.
May prevail. In this case, on 23rd of December, I received counter affidavit. So my prayer is for 2 weeks' time to file rejoinder.
And senior counsel appearing on behalf of the petitioner states that a copy of counter affidavit has recently been served, which requires consideration and filing of a rejoinder. So stop. As requested, list this matter on 2 weeks. 2 weeks date दीजिएगा.
Serial number 23. CWJC 5722 of 2021. Anil Kumar Gupta versus the State of Bihar for the petitioner Mr. Sri Sasibhushan Kumar Manglam and Avnish Kumar for the state Sri Rajiv Roy for the municipal corporation Sri Girish Pandey.
May I claim notes?
Yes.
Petitioner about the Deputy Chief Councillor of Bar Nagar Parishad.
Yes.
And initially he had filed this writ petition for causing of annexure 1 at page 14 of the writ petition, which was the notice issued by the executive officer for holding the special meeting minutes on 11/1/2021 for consideration of no confidence motion against the petitioner. But during the pendency of the writ petition, since the special meeting was convened, filed IA number 1 of 2021, is sealing the proceedings of the special meeting in Annexure 2 at page 15 of the interlocutory application. And its outcome. The challenge has been made on twofold. The first one is the notice in Annexure 14. In Annexure 1 at page 14 of the writ petition. And since it was in violation of the statutory provisions was contained under Rule 2.4 of the Bihar Municipal No Confidence Motion Process Rules 2010. The notice was not a valid notice in the eye of law.
Annexure 1 is not a valid notice.
Not a valid notice.
Why?
For that, my lord, may kindly have a glance of Rule 2.4 of the Bihar No Confidence Motion Process Rules 2010. Rule 2.4 Rule 2.4 very clearly contemplates that the notice issued for considering no confidence motion May I read, my lords?
Yes.
The notice issued for considering no confidence motion against the chief counsellor, deputy chief counsellor said clearly contain the reasons, allegations on which basis the no confidence motion is to be brought. Now, if my lord may kindly have a glance of the notice again, lords, with this statute.
So where is the notice?
I'm sorry, lords.
Where is the notice?
Lords, page 14 of the writ petition, lecture 1.
Page 14 is Aadhaar card.
Page, the next page, lords.
Just a minute. Just a minute. You may be correct. You are correct. Yes.
Lords, it is from Nagar Karyapalak Padhikari Nagar Parishad Bar Patna, addressed to one of the councillors, lords. माननीय नगर पार्षदों के द्वारा प्राप्त अध्यपेक्षा के आलोक में नगर परिषद बाढ़ के वर्तमान माननीय उप मुख्य पार्षद को पदच्युत करने अविश्वास प्रस्ताव पर चर्चा और मतदान हेतु विशेष बैठक की सूचना। उपयुक्त विषय माननीय मुख्य पार्षद महोदय की सहमति से नगर परिषद बाढ़ के बोर्ड की एक विशेष बैठक नियमानुसार आहूत की जाती है। बैठक की तिथि 11/1, समय
Which provision, Mr.
Rule 2(4) of the Bihar Municipal No Confidence Motion Process Rules.
Yes. Motion rules 2010.
10 lords. ले आओ बाहर, ले आओ बाहर।
You are Vinay Kumar.
No, lords, I'm Lords Anil Kumar Gupta. Since by the time this petition was filed, the notice was not served upon me. Therefore, a copy of
This is not a notice under 2(4).
This is not the notice under 2(4).
No.
Then there is no other notice of this special meeting.
That notice is to go to you. Where is your notice?
Lords, a similar notice was issued to me also, but by the time
Similar notice.
then I will bring it on record.
This notice is only for the purpose of participation in the meeting, and that notice is for no confidence.
Lords, my lord, may kindly say, lords. Lords, a similar notice, a copy of this notice.
Have you not brought on record your notice?
Lords, I will then.
Why?
Lords, I
This is highly improper.
Lords, by the time this
Do you take this plea that no notice was ever served on you?
I have not said. I have not
Then
said.
why?
I have not said, lords, and I cannot take this plea.
Then why have you brought on record a notice which is not?
Then I'm sorry, lords. Then it will come, lords.
No confidence motion was being brought against you. Now read rule. You are reading rule 2(4) and then this notice, which has nothing to do with rule 2(4).
Lords, this is the notice under rule 2(4).
What is this? This is notice under. You are again saying.
Sorry, lords. I will bring my notice on record. 1 week time may be granted. my lord.
Where is the question of why? Why should we entertain such frivolous applications? How dare your client can rely on this notice?
Let's say a counter affidavit has been filed on behalf of the executive officer, and these facts are not being denied, my lords. That a similar kind of notice was issued to all. Plus, I will bring.
Mangalam,
Your lordship may grant me, my lords, I am not.
please don't play hide and seek in a proceeding under Article 226.
My lords, I will not, my lords. I will bring it on record. I will bring, my lords.
I am cautioning everyone.
I will bring it on record, my lords.
This you are making a mockery of proceedings like 226.
My lords,
You
I
are
will.
relying on this P1.
I will bring on record the notice issued in my name also. my lords. I will bring it on record. 1 week time may be granted to me.
Now let come to 2.4. You are a seasoned counsel. You are relying on 2.4. Come to 2.4.
J. The notice issued for considering no confidence motion
Yes.
against the chief counsellor, deputy chief counsellor shall clearly contain the region's allegations on which.
So that notice is against chief counsellor. Where is the notice against deputy chief counsellor? Where is that notice?
But this is the notice.
Purpose of participating.
उप मुख्य पार्षद को पदच्युत करने होती हेतु.
तो चूज करने के लिए तो आपको नोटिस दिया जाएगा ना. Allegation is against you.
Milords, the notice.
Allegation is not against Vinay Kumar.
Milords, notice will not.
Vinay Kumar's notice.
Milords, the notice would not only go to the deputy chief counsellor, it will also go to all the ward councillors.
Mr. Mangalam, I believe we are clear in what we are observing.
Milords, a similar kind of notice.
Why did you not bring on record your notice?
Milords, I will therefore I will.
Why should you now?
Milords,
Why now?
Milords, day after tomorrow I will bring it on record.
Why? This application was filed in February 2021.
Milords, since it was.
Why did you show this notice to us?
Milords, because a similar notice was also given.
Why a similar notice? You are the petitioner. You are being removed. And you are referring this to a notice issued to a member.
Milords, by the time, Milords, when the writ petition was filed, I'm sorry, Milords, by the time the writ petition was filed, since that notice, the copy of this notice which was given to me, Milords, it is the same notice, Milords. I assure your Lordships that it is the copy of the same notice which was given to all the ward councillors. And I will collect and bring, Milords, many of them before my Lords. Only one occasion may kindly be granted to me.
I want notice whether requisition was served on you.
No, it is not required to be served upon me.
You are knowing what were the allegations against you.
No, how I can know? I can know only about through the notice. Because the requirement is that the requisition would go to the chief counsellor, not to the deputy chief counsellor.
So you did not participate?
No, I did not participate.
And you were not knowing about the notice?
No, Lords. I was not. About the charges. What are the charges against me? Since the law does not contemplate that the requisition would also go to the deputy chief counsellor, the requirement is only that it would be submitted before, or it would be given to the chief counsellor only. Therefore, the deputy chief counsellor has no access to the requisition in no manner, Milords. That is why, Milords.
All right, whatever time we will give you time.
Only 1 week, Milords.
As requested on behalf of the petitioner, 1 week time is allowed for him to bring on record the notice issued to the petitioner for bringing no confidence motion against him.
Our presence also may kindly be recorded.
Serial number 20.
I appear for respondent number 5, the executive officer of the Nagar Parishad.
Why is such plea is being taken? That
It is the wrong plea. My lord, we are very perfectly right in observing these things. I was just hearing. Our counter affidavit will disclose everything. That notice had been duly, he has not brought it on record. I was just listening to my lord's observations, very apt observations. My lord. Let him file it.
My lord has been
We are
kind
appearance
enough to grant me time. I will bring it on record. But no other lord's notice my friend has brought along with his counter affidavit. Plus, I will bring it on record. No other notice he has brought it on record. Though he has filed the counter affidavit.
Mr. Mangalam, when you approached this court.
Lord, I'm sorry, Lord. I have said sorry, Lord.
My lord, I am appearing on behalf of State Election Commission, my lord.
Plus, it was only because by the time it was drafted and filed, my lords, the said notice was not served upon the petitioner. However, it was served to others. Therefore, a copy was, my lords, brought on record.
Yes.
My lords, it will be coming on Monday, my lords.
Yes.
Oblige.
Serial number 24. CWJC 625 Watt of 2021. Naveen Kumar versus the State of Bihar for the petitioner Shri Shashi Bhushan Kumar Mangalam, for the state Shri Subhash Prasad Singh GA3.
Yes.
Lords, this is also regarding the constitution of a municipality, Lords. I will transmit one of the citations, then it may be heard tomorrow, Lords.
All right. As requested on behalf of the petitioner, this matter tomorrow.
Serial number 25. CWJC 6465 of 2021. Soni Kumari versus the State of Bihar for the petitioner Messrs. Divakar Upadhyay and Preeti Kumar, for the state Shri Arvind Ujjwal SC4.
May I please, your lordship? My lord, this application of the passing of the order, my lord, of the district's committee, my lord, by which the petitioner made an application for grant of, my lord, the PDS license, my lord. The petitioner was at serial number 1, my lord, but a person who has been selected, my lord, he has been given preference over the petitioner, my lord, for the reason that he was an handicapped person, my lord. Though the roster is for the general category candidate. My lord, may please to see the page number 11 of the writ application, my lord. At serial number 37, my lord will see the name of the private respondent, my lord. He has been given preference for the reason, my lord, he was a handicapped person, my lord. The SDO recommended my application for, my lord. I was at serial number 1, my lord, and as per the clause 6, my lord, of the Bihar.
You are referring to which page? Page 10?
Page number 11, your lordship. It starts
Page
from page
11.
number 10. Page number 11, my lord will find. Serial number 37, my lord.
Serial 37.
My lord, Randhir Kumar, my lord. This shop was unreserved, my lord. Serial number 951 is the category, my lord. It is anarakshit, my lord. The person who has been selected, my lord, respondent number 6, he has been given preference, my lord, being a handicapped person, my lord.
Yes.
My submission for my lord's consideration is that as per the clause 6 of the Bihar targeted PDS order, my lord, read with clause 8, my lord, the handicapped persons, my lord, cannot be given priority. My lord, for them, they have already, there are post reserved for the there are the PDS shops, my lord, which are reserved for the handicapped persons, my lord, as per the roster, my lord. That is there, my lord. The suitable candidates was not there, but this is a general category post, my lord.
Control order. Yes.
This is a general category post, my lord, and so any person cannot be get preference over this, my lord. That is my submissions as per the clause 6 and 8, my lord. My lord, I have brought on record the entire list.
What is your qualification?
My lord.
What is your qualification?
My lord, my qualification is, my lord, My lord, I am स्नातकोत्तर एवं कंप्यूटर ज्ञान धारक है, मतलब I have PG, my lord. That my lord will find at page number 8, my lord.
You are a Snattakottar.
My lord.
Soni Kumari is a Snattakottar.
My lord, that is what has been written at page number 8. My lord can see. Page number 8, my lord. Third line from the top, my lord. Soni Kumari.
Yes.
The SDO has recommended by अनुज्ञप्ति योग्य अभियुक्ति में आवेदक स्नातकोत्तर एवं कंप्यूटर ज्ञान धारक है, उन्हें अनुज्ञप्ति को पूर्ण करते हैं तथा अनुज्ञप्ति का आहर्ता को पूर्ण करते हैं. And next page, my lord, at page number 9, my lord will find about the respondent number 6. अनुज्ञप्ति योग्य नहीं है. पहला ही में है हुजूर उनके खिलाफ रणधीर कुमार के में रिमार्क्स में अनुमंडल पदाधिकारी के अनुज्ञप्ति योग्य नहीं है, आवेदक मात्र मैट्रिक एवं कंप्यूटर ज्ञान धारक है. my lord.
Where are you reading? अनुज्ञप्ति योग्य नहीं है.
Page number 9, my lord, on the next page. In remarks column, second column from right, my lord can see अनुमंडल पदाधिकारी का अनुशंसा 15 के कॉलम नंबर 15 में हुजूर देखा जाएगा तो अनुज्ञप्ति योग्य नहीं है रणधीर कुमार.
Page number
9, my lord, of the writ application, my lord.
Page number 9.
My lord.
Page number 9 is not there. At least. No, whether it is.
Annexure 2 starts from page number 10 and page number 9 is the last, my lord. Last page of annexure 1.
Page number 9 is not there in our record.
Then, my lord, I will file a supplementary, my lord, then by bringing the record.
My lord, on the last occasion, my lord has directed the petitioner to annex the reservation roster, my lord, because I have taken a stand, my lord. Randhir Kumar, the private respondent, was appointed on the ground of he is handicapped, my lord, and clause 6C of the Bihar targeted rule, my lord, says that the handicapped person shall be given reservation in accordance with the General Administration Department's provision related to the reservation for the handicapped person in appointment, my lord. Therefore, my lord, he was given preference.
On the last,
as
we had asked you that when you are relying on when you are referring to this section, you must produce what is the General Administrative Department's provisions.
Then, my lord, since the petitioner was directed to bring on record, my lord, either
6.3, but you don't know what the GAD's resolution is or what is the policy.
No, my lord, it is perhaps I have no instruction, my lord, but it is
Very difficult, sir. You are taking a plea and you don't have the document.
Well, may I point out one thing, my lord? By filing supplementary affidavit, my lord, my lord, just a minute, may I point out one thing?
Just a minute. This case on Monday. In the meanwhile, learned counsel for the petitioner will be required to bring on record page 9 of the writ petition, which is not available. So stop. The state respondents shall be required to bring on record the policy regarding reservation in the matter of grant of license for PDS shops.
May I pray for one thing, my lord? It may come, some more time may be granted, my lord.
1 week. Yes.
Obliged.
Anything you want to
26.
Mr. Sanjit Kumar?
My lord, I have filed one supplementary affidavit, my lord. In Annexure 2, my lord, I have brought the entire proceeding, my lord, where selection for
Let us see the policy first. Let us see the policy.
Obliged.
Because reservation has not been granted, preference has been given.
My lord.
There is difference between preference and reservation.
My lord.
Reservation, that if there is a provision for reservation, then that reservation will have to be given. If the provision contemplates preference, then if the two candidates are similarly situated, preference is to be given to say any class of person or candidate.
My lord, I have brought the entire selection process which has been prepared on the basis of the roster. My
Let us have the policy first.
Obligement.
Serial number 26. CWJC 7229 of 2021. Mohammad Khurshid Khan versus the State of Bihar through the Principal Secretary for the petitioner Sri Ram Parvesh Nath Tiwari, for the state Sri Avnish Nandan Sinha GP 21.
May this please,
Sri
my lord.
Ram Parvesh Nath Tiwari.
I appear for the petitioner, my lord. In this case, my lord, to begin with, I must tell my lords that during pendency of the writ application, my lord, we moved the alternate forum, my lord. The case, my lord, was that
you have approached.
We have approached, my lord.
Lord, we have raised a preliminary objection that they have already filed an appeal. Appeal is pending, and yet
This is what he's saying. This is what he is saying, Mr. Giri.
Yes.
The only prayer, my lord, is that my lord may protect the proceedings are pending over there, my lord, till that is decided.
You can, if there is provision for appeal, then the appellate authority must be having the powers to pass any interim order also.
My lord, then till the interim order is passed, my lord, till we move for a passing of interim order.
No, till if that is good. If you pass an order till you move, and you will never move.
No, my lord may give us a fixed time. We will move within 2 weeks, my lord.
You may, you may not.
My lord may protect us for a week or 2 weeks, whatever pleases my lords, my lord. Only till then, when they decide my interim application.
This writ petition was filed in March 2021. We are in 2022.
But there is a stay, my lord.
Sir, Anshul, an interim order is only valid insofar as the proceedings are on. Beyond the proceedings, how can an interim order continue? Once it is being finally disposed of, you cannot claim any interim relief.
Mr. Ansul and counsel appearing on behalf of petitioner.
Basic protection only, my lord. For some time since my lords have protected us.
May I point out one thing?
Preferred and appeal against the order which is impugned in the present application before the appellate authority which is pending. Stop. In such view of the matter, this application is disposed of with a liberty to the petitioner to pursue his appeal and seek interim protection by making appropriate application before the appellate authority.
Serial number 27. CWJC 7548 of 2021. Dr. Janardhan Sharma versus the Union of India through the Secretary. For the petitioner, Messrs. Munna Prasad Dikshit, Sanjay Kumar Chaube, and Swastika. For the Union of India, Sri Vindhyachal Rai.
My lord, pass over for the day, my lord, because net problem here, my lord, and hello.
It is stated by learned counsel for the petitioner that because of connectivity issues, he is not in a position to properly address this court. Stop. As requested, list this case on Monday.
Yes, tomorrow, my lord.
Tomorrow.
Serial number 28. CWJC 8885 of 2021. The Union of India versus Shyam Shankar Prasad. For the petitioner, Dr. Anand Kumar. for the respondent,
My lord,
say Messrs. Munna Prasad Dixit and Sanjay Kumar Chaube.
My lord, I am appearing for the petitioner, my lord. The instruction
lord,
was,
same
my
prayer,
lord,
my
for
lord.
filing counter affidavit.
Who is for the petitioner?
My lord, I am appearing for the petitioner, my lord. Am I audible, my lord?
No, there is some problem with you, Mr. Anand Kumar. Yes. Please unmute.
Some problem, madam. इसको पास ओवर
Yes, Mr. Anand Kumar.
There is
Granted for filing counter reply, my lord. May I kindly see my
As requested on behalf of the respondent, list this case tomorrow.
Serial number 29. CWJC 8971 of 2021.
Same. As requested
same
on
problem,
behalf
my lord.
the
I'm appearing for railways.
petitioner, list this case tomorrow. Then counsel
Serial
for
number 30. CWJC 9509 of 2021. Geeta Devi versus the State of Bihar for the petitioner Messrs. Rajiv Ranjan and Sasibhushan Kumar Mangalam for the state Sri Yogen Prasad Sinha AG 7.
Because it is also a constitution matter, my lords. It may be heard tomorrow, my lords.
tomorrow.
Much obliged.
As requested on behalf of the petitioner.
Serial number 31. CWJC 9847 of 2021. Saraswati Devi versus the State of Bihar for the petitioner Mr. Sanjeev Kumar Misra and Mani Jaiswal.
Lordship,
Okay.
Lordship, in the last order, the state was directed to file a counter affidavit, Lordship, but a counter affidavit had not been received.
Yes. State.
Yes, Your Lordships, I am appearing on behalf of the state. A copy of counter affidavit has been filed, Your Lordship, in the present matter.
Counter affidavit, just a minute. Yes, counter affidavit is there.
Lordship, a copy has not been received by me, Lordship.
I will be serving it by today itself, Your Lordship. Since it has been filed by the other office, that is why, Your Lordship, it has happened.
It is stated by learned counsel appearing on behalf of the petitioner that the counter affidavit filed on behalf of the state of Bihar has not been served upon her. Stop. Let a copy of the counter affidavit be served on learned counsel for the petitioner in course of the day. List this case 1 week so as to enable her to file, to consider the counter affidavit.
Highly obliged.
Lordship.
Serial number 32. CWJC 9917 of 2021. Rita Tiwari versus the State of Bihar for the petitioner Messrs. Anirudh Mishra and Amit Kumar Mishra for the estate Sri Rajiv Raj GP1 for Municipal Corporation Sri Sanjeev Nikesh.
Yes. Yes. Yes, who is for the petitioner?
Sri Amit Mishra.
There is no, despite. So has he joined?
Perhaps Lordship, both members have not joined the process.
Despite link of hearing of online matter having been successfully sent to learn counsel for the petitioner, he has not. Stop. List this case on next Monday.
Monday, Lords.
Yes.
Serial number 33. CWJS 1942 of 2021. Santosh Kumar versus the State of Bihar for the petitioner Sri Santosh Bharti for the estate Sri Kumar Alok Kessi. Sri Santosh Bharti, please.
I'm appearing for the state in this case, my lord. I'm appearing for the state.
There is no representative on behalf of the petitioner. It transpires that the petitioner's grievance is relatable to respondent number 5 contesting panchayat election on the basis of a caste certificate showing him to be belonging to extremely backward class category, bracketed Dangi. Stop. Despite link having been sent to despite link for online hearing of this matter having been successfully sent to learn counsel for the petitioner, he has not joined the present proceeding. So, in any view of matter, this application appears to have become infructuous as panchayat elections have already been concluded in the state.
The state is represented, my lord.
This application stands.
I'm for
Yes.
the state.
Yes. Next.
Serial number 4. CWJS 0089 of 2021. Bablu Kumar works with the Union of India for the petitioner Sri Sanjay Kumar Sharma for the Union of India Dr. K.N. Singh.
May it please your lordship, on behalf of the petitioner, your lordship, this application I file your lordship for requesting the order of the Honorable Cadet Bench Patna, your lordship, by which the petitioner claim of the reservation has been rejected without the going the merit of the impugned order, your lordship. Lordship, the petitioner is applying the railway for the post of the assistant loco pilot and other technical post, your Lordship, under the scheduled tribe category, your Lordship, which has been provided by the government of Bihar. Side notification 2016, your Lordship, which is there in extra 3 series, your Lordship. On the account that the railway has referred a letter of the railway department, your Lordship, in which basis they had rejected the claim of the petitioner, your Lordship. Petitioner has not selected in the final year, Lordship. Then he seek the RTI.
Please come to page 83
My Lord.
of the writ petition.
My Lord.
And read the sentence which begins at in the 10th line at page 52 of OA.
My Lord, sir. 83 is the impugn order of the that bench, your Lordship.
Yes. So just in the middle of that page, the sentence begins with at page 55 of OA.
My Lord.
What is wrong with the reasoning?
My Lord, sir, it may be clarified in the annexure 1 series, your Lordship. Initially, the respondent petitioner number 1 has filed the RTA reply, your Lordship. The reasoning has been given by the respondent earlier that you have got the less mass of the ST category, so you have not selected, your Lordship. Not satisfied in this reply, your Lordship. The petitioner number 1 filed the appeal, your Lordship. Another answer has been given by the respondent, your Lordship, that you have not as a ST candidate, not considered as a ST candidate, so you are treated as a general candidate, so you are not selected, your Lordship. That's a two different question, your Lordship. Answer applied by the respondent, your Lordship.
The tribunal says that even if you are treated as ST candidate, you could not have qualified because your...
My Lord, sir, already 40 seat has been vacant, your Lordship. It is admitted, your Lordship. 40 seat still in the ST category and vacant in the assistant loco pilot post, your Lordship. And that why the earlier the court has framed the 4th question, your Lordship, by order 21/9/2009, your Lordship. My Lordship, kindly see the order 21/9/2001, your Lordship. And in reply to this question of the Honorable Court, the respondent accepted that 40 posts still vacant in the assistant loco pilot post, your Lordship. So far, respondent number 2 is concerned, is the 2 person is selected on the post, other technical post, your Lordship. That respondent petitioner number 2 had the more marks than the last candidate of the ST category. It is admittedly.
Whether affidavit has been filed in compliance of this order?
My Lordship, that is a file, your Lordship, on the behalf of the railway. And that is a copy answer to me 26/10/2021, or let's say.
So when was the merit list prepared?
Merit list, your Lord, prepared on just your Lordship. Only issue is before your lordship, whether this petitioner are in ST category or not. If that is okay, then this candidate got the selection, your lordship.
We have put a question. When
Right.
was the merit list prepared? When was the panel prepared?
I just want to give you your lordship.
What is this?
Just giving the detail, your lordship.
All right, let us come to the tribunal's order. Show us the illegality.
My lordship. Yeah. So for the petitioner one concerned, your lordship, the tribunal has.
So for petitioner number 2, you don't have any case.
My lord, sir, Honorable Court has, in the regard of the petitioner 2, has said that he is not, his certificate is not in ST, your lordship, but the certificate of the result of the certificate, your lordship, it is clearly stated the
Applicant
certificate.
number 1 before the tribunal.
My lord.
Who was applicant number 1 before the tribunal?
1 and 2 both in combined petition has been filed, your lordship, because there are both similar grievances.
Who
So
was applicant number 1 before the tribunal?
Bablu Kumar Pandey, your lordship.
He was applicant number 1.
My lord. Rajesh Kumar Sharma is
The tribunal says that the
lord.
applicant number 1 had less marks than the last selected candidate.
Your lordship.
So therefore, petitioner number 1 cannot have any case.
My lord, but still the 40 post had been vacant, your lordship. Why the court has been asked the respondent, your lordship, by order 21/9/2021, whether the post had been only 2 candidates had been selected or all the vacancy has been curtailed. In this reply, the counter has been filed, your lordship. It is a respondent has stated that
Mr. Sharma, you are not disputing this finding recorded by the tribunal that applicant number 1 secured this much of marks, whereas cutoff marks of ST community was this. So this is not in dispute?
That is not dispute, your lordship. But 14 seat has been not still is vacant, your lordship, due to non-availability of the candidate, your lordship.
According to you, 46 seats are vacant against which you should be appointed.
41, 40 seat here.
40.
40.
40 or 14 or what?
14, your lordship.
14.
My lord.
So what right do you have to be appointed?
If I have to consider as ST, I automatically come on selected, your lordship.
That automatic.
My marks is fractionally less marked to the last candidate of the ST candidate. Fractionally less than mark of the last candidate of the ST. Not even this petitioner come to other ST candidate are also selected if the 40 seat is considered.
Yes. We will have to examine. That's all, Mr. Sharma.
As per the petitioner number 2 as a concern, Your Lordship, the CAT bench has only said that his caste certificate is not as ST. Although the result of the caste certificate, Your Lordship, it is clearly stated the for certificate for SC ST. And it is in his form also stated by the petitioner number 2 as a scheduled tribe, Your Lordship. It is not disputed. Why that this not considered as ST? It is a on this basis, your document, Your Lordship. Certificate of the SC caste certificate is only made for the scheduled caste and scheduled tribe. And he has stated, hey, I am scheduled tribe in the for and everywhere, Your Lordship. Only the tick mark, tick not put up on this column of the ST. That is a.
Yes, who is for the Union of India?
Lordship, I am for this railways, Your Lordship. We have
In the
filed,
second half, we will.
Your Lordship, I have also filed the counter affidavit, Your Lordship, in which we have filed the Annexure A is the Gazette of India, Your Lordship, in which it has been stated, Your Lordship, that the Lohar comes within the OBC, Your Lordship. And Annexure B is the clarification given by the Ministry of Tribal Affairs, Your Lordship, dated 23rd of October 2019. In this, Your Lordship, in the second para, it has been said that as on date, Lohra is in the list of scheduled tribes of Bihar. However, Lohar is not in the list of scheduled tribes of Bihar. And that's why, Your Lordship, they have not been treated as scheduled tribe in the category of scheduled tribe, Your Lordship. And the marks which he has, and the petitioner has scored, Your Lordship, that is much below the unreserved category candidates, Your Lordship. That's why they have not been treated.
Yes, Mr. Sharma.
My Lord, kindly see the Annexure 3 says of the caste of the petitioner, Your Lordship, in which the caste has written in the English, Your Lordship, the 6th letter LOHARA. That is considered by the respondent as a scheduled tribe, Your Lordship. Only difference is the in Hindi, Lohar is written. That is a ground for the hesitation. Although in the Government of India notification, Your Lordship, as Annexure B, as a given by the respondent in the counter affidavit, it is also written in the English as a LOHARA, Lohara, as a treated as ST, Your Lordship. Why is this description has been done by the respondent, as Your Lordship, is arbitrary. Although I have also annexed some name of the Lohara caste as a considered by ST by the respondent, Your Lordship, and then he has in counter affidavit, Your Lordship, they have annexed their caste certificate only written in the English as a Lohara, LOHARA, Your Lordship. Then in that reply, Your Lordship, I have filed the 7th candidate which I have given as a example as a Lohara, which is treated as ST in their caste certificate made in the on the basis of.
We will consider this aspect tomorrow because this will require consideration whether you are. We will consider this aspect tomorrow.
My Lord.
Your Lordship.
Yes.
Your Lordship, court proceeding of the first half is over, Lordship.
No.
Your Lordship.
कितना सीरियल तक हुआ पेशकार साहब?
सीरियल 34।
लंच के बाद बैठेंगे।
तो इसका अर्थ आप सेकंड हाफ में
बिल्कुल
दूसरा है
बैठे
क्या?
ये
नहीं
तो
दूसरा
मुझे नहीं
है, लेकिन इसमें
ये मुझे नहीं पता है। आप लोग अपना कृपया नोटिस देखें और लिस्ट को देखें। मुझे नहीं पता है कि सेकंड हाफ में दूसरा कोई मैटर है। मीटिंग लीव करो।
नहीं सेकंड सीरियली लिस्ट होगा ऑल।
खुद लोगों से मिलता है साला।
हम बोले हैं कि सरकारी नहीं लाए।
साही जी कितना पर हुआ, कितना नंबर तक हुआ? साही जी कितना नंबर तक हुआ है?
थर्टी फोर तक हुआ, 34 तक।
सेकेंड हाफ का कोर्ट स्टैंड ओवर रहेगा सर।
स्टैंड ओवर है।
शॉर्ट कोर्ट नहीं करेंगे जी।
ठीक।
मीटिंग को लीव किया जा सकता है सर।